Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And we're doing a brief preview leading up to the court hearing for Carl Cavalier, who has filed a writ of mandamus against the Louisiana State Police Commission, seeking to force them to have a hearing at which he can present his case for trying to obtain his job back. For those of you who may be new to Sound Off Louisiana, Carl Cavalier was the chief whistleblower. He was certainly not the only one with regard to matters involving the arrest and apprehension of Ronald Green, but he is certainly the one who went by far the most public with it, going all the way to the point of having interviews with WBRZ investigative reporter, chief investigative reporter Chris Nakamoto. He was subsequently terminated for those acts as being a whistleblower, and he filed suit originally in state court. Jill Craft, he originally filed suit pro se in state court. Jill Craft took over as his attorney, moved it to federal court. I'm not going to go into the fact that, well, I'll just briefly say that around September of last year, state police Carl Cavalier, apparently may have said with $200,000. Anyway, one way or another, $200,000. This was in September of last year. Was thrown out as a figure for which Mr. Cavalier may be willing to settle. I will point out that even the very next day he had misgivings, and he recorded all of his phone calls with Ms. Craft. I believe there were a total of either 3 or 4 phone calls at which on various dates he made it crystal clear he did not want to settle. Nevertheless, on October the 6th of last year, a settlement conference was held, and at that conference they say at one point Mr. Cavalier said okay, and once they got those words out of his mouth, never mind that it's not a written agreement, they pretty much said, all right, we're off to the races. I kind of feel like it was the equivalent of fishing, and I've made this analogy, and you got the nibble, you sucked that hook in, and they reeled him in, and they are not going to let this fish off the hook. So Mr. Cavalier retained new counsel because he was upset with Miss Craft said, I got to drop out of this thing because Mr. Cavalier's interests and mine are no longer aligned, and it would be best if we both had our own counsel. She was on the audio of saying that. And so Mr. Cavalier got a pair of attorneys, and they filed a motion to reopen the cause in federal court. That motion was ultimately denied, and so Mr. Cavalier has filed a motion in federal court to have that matter reconsidered. As of now, there's been no ruling on that. I can pretty well assure you that the judge is not going to entertain a motion to reconsider, but you don't have anything to lose trying. Meanwhile, Mr. Cavalier filed a writ of mandamus, as I just said, in state court, seeking exclusively, now this is against the Louisiana State Police Commission, as distinguished from his federal suit, which was against Louisiana State Police, seeking to force the state police, and that's what a mandamus does. It seeks to force a governmental body to do or refrain from doing something for which they have no latitude. A ministerial act, if you will. If the defendant, which in this case is the Louisiana State Police Commission, can successfully argue that they have latitude, that they have leeway, typically a mandamus is not awarded. Mr. Cavalier is arguing that the police commission had an obligation and has an obligation to afford him a hearing, and they have not done so. And he maintains that's separate and distinct from the federal litigation. That's what his arguments are. But here's the things that we're reporting on today leading up to tomorrow's court hearing, because this is Sunday, August the 6th. We give a previous feature, and we'll give you the link for it, wherein the State Police Commission said, all right, here's the deal. Since this thing's going to happen on August the 7th, we want Colonel Davis in there as a witness. We want Jeannie Pellegrin in there as a witness. She is the attorney with Lunar and Pate that's representing state police, along with Attorney Ben Mayu. We want a plethora of documents, including this agreement that was supposedly reduced down to writing, although not signed by all parties. And Ms. Feeney, who is the attorney for the State Police Commission, acknowledged that, hey, I know this stuff was filed under seal, but we're now in litigation, so we need it. And we gave you the link in the previous feature for Ms. Feeney's filings. What we're coming with you today is that state police was not pleased at all with Ms. Feeney's filings, and they basically gave her the equivalent of some bare knuckle, you know. And one of the things and one of the reasons I like reading all of these filings and presenting to, because we have a lot of attorneys that follow this blog. There are a lot of attorneys who follow this blog. And I think it's an opportunity to get an education, because you never know when you're going to face this situation yourself. And I think seeing how these things go is of interest. And I'll point out a couple of quick things. Had Mr. Hike, who was the attorney for Billy Broussard, had he dedicatedly followed this blog, I feel certain he would have filed under Code of Civil Procedure 971 a special motion to strike. When Billy Broussard filed defamation suits, he filed 2 of them, well actually 3 if you include the newspaper. One against Mindy Mob Boss Gerard, along with Melissa Dubrock. That was one litigation. And the other one was against Trooper Scott Lopez, all of which involved public matters. And I believe that if Attorney Hike had simply followed this blog and seen that motions to strike had been successfully asserted. In fact, it was asserted by Mr. Mayu, Mr. Ben Mayu, same attorney that we're dealing with here, against Calvin Braxton, and another 971 was successful against Murphy Painter. Now, that was a different attorney. That was not Mr. Mayu in that one, but nevertheless, that's been explicitly put out there, so all Mr. Hike had to do was have followed a little bit of this blog. Instead, I think he was hell-bent on just making flippant pop shots about this blog, and he's welcome to do that. But he could have gained from it, because I can pretty well let me say this. Had he filed a special motion to strike, and by the way, you can get attorney's fees on that, you can take it to the bank. Judge Bourne would have granted it. Now, granted, legal fees would not have been very high if Mr. Hike had gone that route from the outset. I can only assume that as pretty much a trial attorney, not a defense attorney, he may not have known about 971, but hence my point about what you can learn on this blog. I think that Judge Bourne would have granted it. In fact, I think I'd wager, I don't want to say everything I've got, but I would wager a pretty good wager that Judge Bourne would have granted it. There's probably a pretty good chance that Judge Pittman would have granted it, because I think it would have been well-founded. The courts are reluctant to, well, first of all, a defamation case is hard to prevail on, period. But the courts are very reluctant to stifle anyone's right of free speech about a public matter. And since Mr. Broussard's requested rezoning was a public matter, I believe if Mr. Hike had gone that route, he would have prevailed. But he didn't. So there's an opportunity, I think, to get an education here too, because I will also share with you back when Mr. Broussard had his hearing it's a long time ago now, but one of the things his attorney, Heather Duhan, sought to do was to challenge the constitutionality of the ordinance passed by the St. Martin Parish government. Well, in order to do that, she apparently didn't know this, and so I had said when we did the previous feature, I wanted to, I guess, save a little bit of embarrassment, said that for technical reasons, Ms. Duhan could not argue the constitutionality. That's the reason she could not. When you are arguing in court about the constitutionality of something in Louisiana, you are required to subpoena the Attorney General and get testimony from the Attorney General with regard to that constitutionality. Since she had not previously subpoenaed the Attorney General to appear for testimony, her wings were basically clipped. She was unable to argue those points. And we have a very similar matter with regard to Miss Feeney's filings. And again, she's getting a little pop on the knuckles here from Ben Mayu and Jeannie Pellerin. Now, first of all, Ben Mayu and Jeannie Pellerin, and we're going to give you the documents, the entirety of the documents that were filed by Ms. Pellerin and Mr. Mayu. And you have to realize this is now going into state court, okay? So they're having to file a whole bunch of documents that were originally filed in federal court, but you can't just say, Your Honor, look, we filed all this stuff in federal court. They're having to enter it into the record here. I said all that to say this. We're going to give you a file where I have pulled out a lot of the documents that you've already seen before if you follow this blog. So I'm trying to keep it to just the fresh stuff, the new stuff. However, we're going to put parenthetically if you want the entirety of the file, because we may have some attorneys who want it all, or we may have some who are relatively new to this whole matter and said, no, I want to read it all. Well, that's 80 pages. You're welcome to download it and look at it, but I want you to know the express file we're doing is just the relatively new stuff. All right, first of all, Mr. Mayu and Ms. Pellerin are arguing that she's wanting us to turn over material for which there is a federal court order for the confidentiality, and we filed it under seal. We would be violating a federal court order were we to release this. Now that's one argument. But the argument I want, well, that's one thing that they're posing. That's one item they're posing for this upcoming hearing. And they have filed an emergency protection order, okay? Emergency, wanting expedited consideration of this. Now, I think the biggest expedite you're going to get is they will probably begin the arguments in Judge Johnson's courtroom. They will probably insist on being heard first, which I know I would, and I'm sure they will, prior to, hey, let's kick off any hearing for any mandamus or whatnot. And so beyond just Ms. Feeney, on behalf of the LSPC, is seeking documents that we would violate a court order if we turn them over, but the next part goes back to why I laid the foundation with Mr. Broussard. And if you are bringing in a public official, there are certain hoops you have to jump through. So I want to read from this. We will highlight the actual text in the body of the article, but I want to read it to you now. And I'm reading from page 3 of the memorandum in support, beginning with paragraph 2. Colonel Davis was appointed by the governor as the department head and superintendent of the Louisiana State Police. His counsel, Pellegrin and Mayu, are appointed special assistant attorney general and appear as surrogates for Attorney General Jeff Landry, a statewide elected official. Consequently, the commission is required to comply with Louisiana Revised Statute 13:3667A1 before issuing a subpoena to compel respondents' attendance at trial. That statute provides, and I'm not going to read you the statute, but there's your little free education. In addition to, if you want to get a statewide elected official, because Attorney General Jeff Landry is certainly a statewide elected official, you have to jump through this hoop. And we're going to copy and paste into the body of the feature, but I wanted to really emphasize that part of these pleadings, because again, we have now at least 2 attorneys who either weren't aware of it, those 2 being Ms. Duhan or Ms. Feeney, and felt like maybe they might, well, I'm going to assume that they did not know. They'll have to explain, as to why. I mean, they may be able to successfully argue that, no, we don't have to. I don't know. I just know what I'm reading right here, and I know what the problem was with Mr. Broussard. So that's going to wrap this feature up. The hearing will be tomorrow, August the 7th at 10 a.m. Judge Don Johnson's courtroom. Anyone's welcome to attend. We will be planning to seek commentary for those willing to comment on the hearing after it. I will take the camera. Obviously, as you know, I cannot take the camera into the courtroom. That's something I really want changed in this state, but I don't know if it ever will, because I don't even hear any gubernatorial candidates discussing that. But it's something that is sorely, sorely, sorely needed, bad. Because I'm telling you right now, if you think some shenanigans don't take place in courtrooms, you are living in a fantasy land, okay? And it's a real detriment not to be able to have a camera in these courtrooms. And by the way, let me just say one thing. I learned something as well. If you look at the last feature with regard to Jacob Brown, you heard me repeatedly use the word alley charge. And let me just say this, Judge Doty, who was the judge overseeing that matter up in Monroe, he has a Southern accent extraordinaire. And I thought that's what he was saying, alley charge, when will I issue the alley charge? And of course I've never been in I typically attend far more civil trials than I do criminal, but I've never been in a criminal matter where we had a potential for a hung jury. So I will readily admit I had not heard this alley charge, and so I tried to Google it to learn what I could, with no luck. And then finally, as I kept trying to Google, I guess I'm not spelling alley right, well, finally it came up and it said Allen, A-L-L-E-N, charge. So, and that's basically an encouragement for those in the minority of a jury deliberations to please keep an open mind. And that would have been the Allen charge, which never actually had to be made. You're welcome to Google that and look over it. You know, some attorneys feel like it's browbeating, others say that it's very useful. But at any rate, I like to continue getting educated, and maybe there's some attorneys here that if ever in your career you're going to need to subpoena a statewide elected official, you'll need to follow this statute, because I kind of doubt that Ms. Feeney is going to be able to get around it. So stay tuned, folks. We look forward to bringing you a feature in the aftermath of Carl Cavalier's hearing tomorrow, August the 7th at 10 a.m. in Judge Don Johnson's courtroom. We'll see you again soon.